Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. I have several different videos on estate planning. You're free to look over my channel and get some insight into what's involved, what some of the subjects are. In this particular video, I'd like to talk about trust administration, what it is, why you should know about it, and perhaps why you could need help in getting the particular living trust administered. So let me tell you first of all what exactly this is. So let me give you an example. Let's say that you and your wife make a living trust, and you're young, you're healthy, and at some point in the future, let's say you die, and certain elements happen that take effect at that time, and your wife goes on, lives another 10, 15 years, and then let's say she dies, and now both the people who originally made the living trust have passed away, and essentially at this point here, there are provisions that take effect in the living trust where a trustee has been selected, and now that trustee has to comply and do with the terms of the living trust. And sometimes it's not just a trustee, sometimes there are co-trustees or even more, and both of them have to essentially get along, do what's necessary, maintain their fiduciary capacity as a trustee, and basically do and follow what the intentions were of the settlers, which are the people who originally made the living trust. So that sounds easy enough, right? Except a lot of times it's not. A lot of times the way that the living trust was drafted in the first place is very confusing. Especially if you're not an estate attorney. I mean, just go ahead and read any particular estate plan, the living trust, and there's a lot of terms that are unclear. There's a lot of sub trusts which have no particular meaning to someone who doesn't know exactly what they are. There are instructions which are ambiguous. Like, for example, let's say that there's co-trustees, okay? And let's say that the particular living trust gave instructions that upon death of the surviving trustee, which would have been, in my prior example, the spouse, let's say that that it says all the properties to be divided among the three children. Well, that may not sound ambiguous, but the question is how exactly is the property supposed to be divided? Let's say there's three children. Does that mean that each property needs to have a 30% ownership from each child so that all of them essentially own 30% of every property? Or does it mean that all the properties need to be divided in such a manner as equally as possible to give the 30% of all the properties combined to the particular person? You see where just a simple sentence is ambiguous. And so, part of that is due to the drafting of the trust itself, that it wasn't done in such a manner that made it unambiguous. So, for example, if that particular trust was drafted better, it would have said that there can be a pro rata distribution where other items can be used in lieu of the property itself. So, for example, if one child was $50,000 short based upon the fair market value, they could take that 50,000 in cash or jewelry or whatever would equate to be equivalent to a third distribution. So there's that issue. And then a lot of times the trustees end up also being the beneficiaries. And when you have a trustee who's a beneficiary, a lot of times you'll get a very greedy trustee who will not do what's in the best interest of the trust itself or follow the intentions of the original trustor. and will try to maximize whatever he or she gets. Well, clearly that's a problem because it doesn't comply with the fiduciary responsibilities of the trustee. It violates several different codes as to what they need to do to properly administer the trust. It creates a conflict between that trustee perhaps and another trustee. I mean, I could go on and on with what it is. So sometimes when you get an attorney who will do the trust administration and for you, that attorney can be used as a buffer to basically say, okay, this is what you need to do. You can't do this. Many times there'll be even more than one attorney on a trust administration, where if there's co-trustees, they each co-trustee has their own attorney in order to represent their interests. The lesson there is, maybe if you're going to be a trustor, don't have co-trustees, just have one trustee. But still, you never know when there's going to be problems. But the trust administration itself, there are many different deadlines that have to occur over the next year, including filing the tax returns and notifying Medicare and filing the change of ownership of different properties, the transfer. I mean, there's several different deadlines that do have to occur. So, and there's also the closing out. Obviously, there's with trust administration, doing an accounting of all of the assets and the bank accounts and money and property, and getting a division as requested in the particular trust document itself. So it goes on and on. Many times the trust administration on a reasonably sized estate will take about a year, and so you don't want to have an ulcer over it. So if you can find a good estate planning attorney, go ahead and give them a call. I happen to be in Los Angeles and Long Beach, so if you are local to those areas, just give me a call, set up an appointment. I'll give you a free consultation and try to help you out with whatever your current situation is, and we'll go from there. Okay, more on the coming videos.